Hi, Gary Humble here with Tennessee Stands, and I wanted to take a moment to give a little bit of commentary and talk with you about some things that are going on in our legislature right now. Many of you might know that there is an ad hoc committee meeting right now, a joint session of our House and our Senate over the emergency powers statute and potentially what sort of changes they would like to make in next year's legislative session. And they've just had recently their second meeting on Thursday, September 3rd, and I believe there's one more meeting to go. But I've got some clips for you from this last meeting, from the hearing, and there's some things that I wanted to point out, and I also wanted to talk about that a little bit. So in this first clip, we're going to look at our Attorney General here in Tennessee, Herbert Slatery, and he's here basically to defend the emergency powers statute as is. And shockingly, what I'm about to show you is for the most part the meat of his testimony. So here's that.
Does the governor have the authority to issue executive orders that he has? Yes, on the whole. The answer to that is yes. Is Tennessee Code Annotated 58-2107 constitutional? Yes. Are mask mandates constitutionally defensible? Yes. And do the governor's emergency powers and executive orders preempt conflicting actions by local governments? Yes. So we think there is some clarity in all of these.
Now there's some key things I want you to take away from his testimony. There's not a lot of, well, this is constitutional because of this article or this section, or, here's what the law says, or it's, is it constitutional? Yes. Are masks constitutional? Yes, of course they are. Yes. Personally, I would have liked to hear a little bit more than just, yes, trust me, this is all constitutional. And I'm no body language expert. I bet you there are some watching this video that might be. Just pay attention to the swiveling in the chair and the kind of slouching over, the low voice, the looking down, not making eye contact, the hands tucked under the desk. I'm just watching this guy say, oh yeah, sure, it's constitutional. And I'm just gonna be honest, it doesn't look to me like he believes a word he's saying. So there's that. But that was the defense of the statute in front of this ad hoc committee from our Attorney General, by the way, who will be defending the governor in our lawsuit. So in this next clip, I want to take a look at Professor Glenn Reynolds. Really loved what he had to say. I've got to tell you, I've never personally met Mr. Reynolds. I would love to sometime. I don't know if he's heard of Tennessee Stands or seen the videos, but I was excited to see that pretty much everything he had to say lines up with the argument that we've made. He is a constitutional law professor at the University of Tennessee in Knoxville. And so take a listen to this first clip.
Tennessee Constitution is, in fact, somewhat more aggressive in protecting individual liberty than the state constitution. As the Tennessee Supreme Court has pointed out more than once, it's the only state constitution that explicitly, right up front, states that there's a right to revolution against a government that is arbitrary or oppressive. And from that, you can also take the lesson that you couldn't possibly expect the Tennessee Constitution to confer the power to be arbitrary or oppressive on the government that it creates.
Notice here he's talking about Article 1, Section 2 of our Constitution, which essentially gives Tennesseans a duty to resist arbitrary power. In fact, it says the doctrine of non-resistance is slavish and absurd. So to not resist anything that we would consider arbitrary power in the state of Tennessee, our Constitution literally looks at us and says, you're absurd. That is crazy to do that. It is destructive to the good and happiness of mankind. I really appreciate him pointing that. Super important. That is one of the opening mandates of our state constitution. Take a look at this next clip.
And Article 1, Sections 1 and 2, separation of powers, which I think does come into some of the things you may want to think about in terms of remedial legislation. And this is one of those places where I have to qualify. There are two ways to interpret a constitution. There is to predict what courts will do, and there is what I think is right. Shockingly, those two things do not always overlap. Tennessee courts have been quite lenient in interpreting Article 1, Sections 1 and 2. It reads as if it's a very strict separation of powers provision. It has not really been treated as such by the Tennessee courts. But you all take your own oath to the Constitution, and you are entitled to form your own judgment about this sort of thing. And if, in your opinion, some of the things that go on constitute a constitutional violation, you're entirely free to legislate to keep that from happening, regardless of what the courts say. The courts are supreme in their own sphere, but you have your own sphere as well. And as long as you are concerned about the constitutionality of any particular action, you're perfectly free to legislate to keep it from happening.
And just a small correction. I know that what he meant to say when he's talking about the distinction and the separation of powers is it's actually Article 2, Sections 1 and 2 of our state constitution. But our state constitution does a great job at delegating powers to the different branches of our government and going so far as to say, by the way, just to make sure you get this, the legislature can't do the governor's job, and the governor's job can't do the court's job, and the court can't do the legislature's job. So it does makes a really great point of there not being any overlap in our branches of government, creating a very strict and real separation of powers. But something that I want to make sure you caught that he said was incredibly important is when he talked about whether or not the courts had ruled or had even at some point discussed a part of the Tennessee Constitution, and how that should not prevent the legislatures from doing the job of interpreting the Constitution for their own selves in how they legislate and create policy for the people of the state of Tennessee. He really put it to the legislature on, look, you have some responsibility here during this time of emergency. There's a lot of things our legislature could have done. They could have called a special session. By the way, we've been in this issue since March, and our legislature came back into session on June 1st and did nothing about any of these emergency powers issues that we're struggling with. So there's a lot of responsibility and weight that our legislature carries for not acting. We're still looking at Mr. Glenn Reynolds' testimony. So here's the next clip.
And one provision I want to call attention to, for a long time I taught the Tennessee Constitutional Law course with the bar review courses for Barbary and before that, West. It's Article 11, Section 16, which is a provision of the Tennessee Constitution that the courts certainly haven't done very much with. But it provides that the Declaration of Rights, all the rights spelled out in Article 1, are accepted out of the general powers of government and shall be forever inviolate. Now, I read that, and again, this is where you're talking about what I think about the Constitution, not what the courts have said, because they've said practically nothing about this provision. If they are accepted out of the general power of government, that means that neither the governor nor the legislature, nor for that matter the courts, has the power to act against any of those rights guaranteed in the Declaration of Rights. And for example, things you might see in other cases, and especially in federal jurisprudence, where you balance an interest against a right, go right out the window. You can't balance an interest out of a right when infringing the right is not even a governmental power at all, but is accepted out of the general powers of government.
A couple things that I'm really glad he pointed out. For one, our governor, in no way does the Constitution insinuate that he makes or creates law, but he executes on the law. But also, man, it fired me up. It's something that I've talked about a lot. We've shared it in our videos on Tennessee Stands. It's like a little known thing in our Constitution. In fact, he acknowledged our courts have never, that he's aware of, have never even weighed in on this. But clearly, in Article 11, Section 16 of our Tennessee Constitution, which, by the way, has been in our Constitution since 1796, that the Bill of Rights, or the Declaration of Rights in Article 1 of our state Constitution, per this Section 16, Article 11, has been accepted out of the general powers of government. And I was pretty sure I knew what that meant, but Professor Reynolds, again, was very clear that this means, essentially, that in those Declaration of Rights, the entire government, the courts, the legislature, the governor, every elected official, every member of our government has no power to strip those rights and liberties ever under any circumstance away from the citizens of Tennessee, and that they shall forever remain inviolate. So thank you so much, Professor Reynolds, for bringing out that article of our Constitution in front of that ad hoc committee. I thought that was brilliant. Last little thing from Professor Reynolds. Here's his interpretation of, he was asked the question on what could be arbitrary, and here's what he had to say.
You mentioned arbitrary several times in your discussion there. Could you expound on what would not be arbitrary versus what possibly is in relation to Title 58?
Yeah, arbitrary, I know this is a term we use in a lot of areas, including in administrative law, which I also teach. You're arbitrary when your decision making is not driven by the facts. An agency is arbitrary when it's not considering the factors that the legislature has told it to consider. In this context, the governor is arbitrary when what he's doing doesn't seem related to the actual mission he's supposed to be addressing. So, for example, if you want to reduce the spread of a disease and you close some institutions and leave other institutions that are functionally identical open, that raises a suspicion of arbitrariness.
So you mean maybe it's unconstitutional for the governor to call certain people non-essential? Yep, I think so. And I know so do many of you. Here in this final clip, I want you to listen to some final thoughts from an attorney based out of here in Williamson County. His name's Larry Crane, and just a really well-known constitutional law attorney here in Middle Tennessee. And so take a listen to some of these thoughts.
James Madison, one of the authors of the Federalist Papers, didn't originate the idea of checks and balances limiting government, but he helped push it farther than anyone before or since him. Madison said checks and balances are necessary because men are not necessarily all angels. I submit to you the Constitution of the State of Tennessee vests in the General Assembly a solemn duty and obligation to serve as a check on the ability of either branch, whether it's executive or judicial, when they usurp their constitutional authority. To prevent future governors from trampling the civil liberties of the citizens of this state during emergencies, some checks, I believe, are essential in some fashion on the broad powers granted to our governor. And I will close with this. If our courts will not intervene, when governors abuse their discretion, even to the point of infringement of religious liberty, then our citizens must look to you, the legislature, to champion that freedom and protect us from tyranny. And I respectfully urge the committee to explore alternatives that restore a system of which assures accountability and it serves as a check on the broad, unlimited powers conferred on our executive branch in times of emergency. Thank you very much.
So I sort of want to close up this video with that final thought from Mr. Crane that I thought was just really strong to have stated before these legislators. And it's this, that, you know, whenever the courts fail to do the job, it is still on the job of our legislators, our elected officials, to check the power of our governor. And those checks and balances go both ways, but that's been something that I've been very vocal about during this season, is that, look, we've not seen anything from our legislators. I believe it was just a week or two ago in Idaho, their state legislature stepped up and passed a resolution and put a cease and desist on their governor's emergency powers. We could do that here in Tennessee. That is within the General Assembly's prerogative, but we simply haven't. And so as citizens, we're just, while they're meeting in a committee, we're just left continuing to struggle under these unconstitutional emergency powers and spending money, filing lawsuits, which of course, take time. while we're still struggling through the emergency powers. So it's all a mess. And I would issue the same challenge: step up, do something. If the governor is going to continue to unconstitutionally renew these powers, like he probably will on September 30th, it's on you, General Assembly, to step up to the plate. You've been told by some men who have a reputation of understanding our Constitution very well that this is part of your duty. And us as citizens, we expect that of you. In fact, it's why we elect you to office. Thank you all for watching. Please share this video. And if you haven't, just want to encourage you again to go to TennesseeStands.org and sign the resolution and share. And obviously, as we're engaged in lots of legal battles and making education efforts like this and events and things we're trying to do to build this state coalition, would you please consider going to our website and clicking on the donate button and joining us financially? We appreciate all your support. See you next time.